My next guest is knee-deep in this stuff, and that pun was intended. Please welcome into the show Roger McEowen of the Washburn School of Law. Okay, Roger, I mean, this is a big deal, and I kind of feel good about it, but I don't want to get overly excited because, I don't know, it always seems like something comes around the corner that I wasn't expecting. What's up?
Yeah, you always fear that the rug's going to get pulled out from underneath you. But no, this is a very big deal. And I think the point to be made here is we would have never gotten this ruling that we got yesterday had the EPA not continued to push the Sacketts into a corner and just get them into a position where they had no choice but to file a lawsuit. You can't continue to have these fines run up on you. You can't pay that. So your only recourse is to sue. Well, the politics changed, and you got justices on the court that are constitutionalists, at least enough of them. I'm not sure what Kavanaugh was doing yesterday, but 5 was all it took. And the EPA lost, and they lost big time. And this wipes out the Biden administration's WOTUS rule because the significant nexus test is gone, and the court is restoring the historical interpretation by the EPA and the Corps in the 1970s that said, yes, we have jurisdiction over waters that are truly oceans, rivers, and lakes, and things that you can navigate on. We're basically back to that. They said there has to be a continuous surface connection from an isolated wetland to a water of the United States. And that's a big deal. That throws out the significant nexus test, which could connect in the Sackett situation, their lot with a ditch, with a creek that ultimately flowed into Priest Lake. That kind of elbow and knee and ankle connection is gone. The one thing, Scott, actually two things. The one thing first, Scott, I would point out is this doesn't necessarily curtail pollution control efforts because the term discharge under the Clean Water Act is separately defined, and that's still defined broadly because of a Supreme Court decision a couple of years ago that came out of Hawaii. The other thing farmers and ranchers need to be aware of, and farmers in particular, is that Swamp Buster has an entirely different definition of wetland than does the Clean Water Act. So a farmer could be deemed to be in violation of the Swamp Buster rules, lose their farm program payments, but yet now, because of this opinion, not have to worry about the EPA or the Corps asserting jurisdiction.
I'm going to go a little off piste here. I mean, it seems to me like from 1970 onwards, was this like the result of the climate crazies getting a hold of this law and really kind of interpreting it to the nth degree?
I think that's a fair point. What happened in the 1970s was you had the initial regulation that came out by the Corps and the EPA, and it was very reasonable, and it was in line with what congressional intent was according to the legislative history. Then the activists started suing. And they got activist judges, and the opinions started coming down in the late 70s. Throughout the 80s, you get the Bayview Holmes opinion. And it wasn't until Scalia's plurality opinion in the Rapinos decision in 2006, which, by the way, yesterday, this is what the majority has now adopted, is pretty much verbatim what Scalia said in 2006. Now, the other 4 said, we agree that the Sackett's property was not a wetland, but we think the majority took too narrow of an approach. So that was kind of a concurring dissent, if there is such a thing. They didn't formally dissent, but they disagreed with the narrowness that they viewed was the majority opinion. But you're right, it was the activists that got a hold of this, started suing in the late 70s, and then the activist judges reinterpreted the statute, and then the regulations started to change. And now the Supreme Court has said, look, we're not going to give you any deference. In fact, none of the justices mentioned Chevron deference at all, which is kind of a tip of the hat, I think, to what's coming next year in another case. And they said, we're going to change this rule. We're going to go back to that original interpretation.
Okay, so just to dumb it down for myself then, it was a 5-4 ruling, correct?
No, it was 9-0 on the issue that the significant nexus test is the incorrect test and that the Sacketts did not have a wetland. That was 9-0. They all agreed on that.
Okay.
And that's major. What was 5-4 was that the 4 justices, Kavanaugh and Sotomayor and Kagan and Jackson, said that the majority's new test, this continuous surface connection, was too narrow.
Okay, so that's what I feel like they ruled against common sense then, if you ask me, right? Because I totally concur. I agree with the 9-0. But it seems to me that they just went back to, as I say all the time, common sense isn't common. That's not that common anymore. But it feels like it's now being interpreted like it was meant to be interpreted. But I'm still a little upset that they could kind of have a dissenting voice against what was meant to be interpreted, right?
Yeah, I think that's a fair statement. But keep in mind, there was only 4 that said that what the majority was saying was too narrow. So that doesn't count.
Okay. All right. Well, I really appreciate you coming on, because I feel, I'm going to be happy in the short term. I don't want to make sure nothing comes back to bite us here, but sometimes the rug does get pulled out from underneath. But I feel I'm glad those people stuck to it, and hopefully everything really works out for them in the end.
Everybody in agriculture is glad that they stuck to it. Nobody likes to be the guinea pig or the poster child for this kind of thing, but we are very thankful that they stuck it out.
All right. Thanks very much, Roger McEowen, coming to us from Kansas. Thank you very much for being on the show. All right.